Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Happy Friday. It's Freaky Friday. We're going back to Salem today. We're going back to Salem, Essex Superior Court, Massachusetts, for a motions hearing on Kelsey Fitzsimmons' case. The SJC has not yet ruled on whether or not her bail conditions are unconstitutional or whether or not the judge overstepped her authority in requiring Kelsey to blow into that SCRAM device when she is medically unable to do so. And so we do not know if Kelsey will be home for Christmas because there are only 3 working days left until Christmas. And wait till you hear what I have to read for you today. Justin's opposition to the grandparents' motion. Grandparents, prepare to be outraged. Parents, prepare to be outraged. Everyone prepare to be outraged. The misogyny in Massachusetts is showing, and it's repulsive. And you should be outraged. You should be outraged. What would be taking the SJC so long? I don't know. They agreed that they were going to start looking at it on the 2nd. There was not going to be oral argument on it today. It's the 19th. End of year, they have a lot of cases. I don't know. I can't make excuses for them because they honestly don't know the answer. It's repulsive. Disgusting Justin. Let's just call him Disgusting Justin because that's what he is. He's disgusting. Is he really concerned about the best interests of his child? The best interests of his son, who's now 10 months old? Is he really concerned about that? Or is there something more here? I don't know. But it's horrific. And Kelsey sits in Chicopee without her family nearby. It's 2 hours from Essex Superior Court, approximately each way. And Tim Bradl made a motion yesterday to see if they would transport Kelsey to court for this hearing today. And they said, no, we're not going to do this. She can come on by Zoom. Even though Tim Bradl and Martha Coakley, or defense counsel, is required now to come in person for every single hearing to Salem because, apparently there was so much public interest in this case that their phone lines couldn't handle it. Because the last time I think there was a hearing, it was, the party line system, not Zoom. It was just the party line. And it overwhelmed the system and they couldn't handle it. So we'll say, I don't even want to log into the Zoom yet because if anybody here in the chat is on the Zoom, let me just please remind you, you must mute yourself. You must mute yourself. In fact, muting yourself when you enter a Zoom hearing should be your default setting. Muting and no camera. Camera off and mute. Because the last time we covered a hearing, I don't even remember what case it was. I think it was Aiden Carney's case. once again, someone had me playing in the background while they were on the Zoom. They weren't muted, and you could hear my voice through the Zoom meeting. And it wasn't me who didn't mute. It was someone listening to me. And I love that you listen to me. And I love all the hate watchers that watch me and listen to me too, because, you know, a view is a view. But you need to be on mute because a lot of people know my voice. So I hesitate to even log on to the Zoom. Maybe I'll log on to the Zoom and just not say a word until they connect us, because that's the only way that I can guarantee that my voice is not going to show up on the Zoom call again. This is why we can't have nice things. Oh, please. It's not, she doesn't have the right to be there in person. She has the right to be there, but not necessarily in person. And that's unfortunate because she's in custody. We saw that happen with Brian Walsh a number of times too. He zoomed in. Anybody see that embarrassing press conference last night in Providence? Do we have any Providence folks in the chat? Are you embarrassed for your mayor? What the hell was that last night? It was embarrassing. Absolutely embarrassing. And then Leah Foley also did a press conference after the Providence press conference, or maybe at the same time, but the station that I was watching aired them both. There was the press conference in Providence, and there was the press conference in for Leah Foley did, because apparently the same shooter that was involved in the Brown shooting was also the shooter of the MIT professor in Brookline. Well, there's one case that Norfolk County is not going to have to prosecute because the shooter allegedly killed himself in his storage unit in Salem, New Hampshire, because you can't make it up. You just can't. I think I may just be silent until this Zoom hearing starts, because I really don't want my voice coming out on the thing. Hang on. And so if anybody's just joining and they want to know why I'm silent, that's why. This is why we can't have nice things. I heard that Judge McCarthy Neyman has reassigned herself to the trial of Kelsey's case. I don't know if I have any court documents yet to back that up, but Judge Drexler is allegedly on the daily calendar for today's motions hearing, so we will see. We will see. So much stuff happening everywhere. Yes, it happened last time when it was Aiden's hearing. Maybe I'll just whisper. I'll just whisper for now. Let's keep it over there on the separate screen. Hold on, because the host has joined. The host has joined. Put yourself on mute if you're in the Zoom. Please, kindly. Thank you. I don't know. We also have the reply brief to look at as well. Boy, if my kid was at Brown, I would be angry. I'd be pulling my kid out of Brown right now. Judge Drexler is incredibly intelligent and a well-reasoned judge. And he knows a lot about police procedure because when he was an attorney, he told us that he handled thousands of interviews for police. I'm just going to remain silent. That's what I'm going to do. What do you mean? Judge Drexler was only briefly back out? But it says he's on the calendar today. Oh, the president of Brown instilled zero confidence in me. You have the right to remain silent. I'm going to. Oh, Aunt Baby, you figured it out? It could be. All right, so that's why I'm going to mute myself because people don't mute when they're on the Zoom and then my voice comes through. So you can explain to everyone that comes in that doesn't understand. That's why I'm whispering. Because we have 1 minute until go time. It's like a silent retreat. We're going to a silent retreat. We're going to try. It's probably not you. It could be a troll. It could be a troll. Thank you. This is why we can't. Oh, it's so windy right here too. It's windy as heck. And it's so hard for me to not speak. Okay. There. You don't speak. So. We're just waiting. I know it's hard. When it's up, you'll hear it. See if they let me in. I don't think anybody's broadcasting it live, like any news organizations. If you know that they are, let me know. It's supposed to start at 12. It's 12:04. Everyone's whispering now. That's what we're doing. Talk amongst yourselves. Talk amongst yourselves. If somebody wants to send me a link to the NBC 10 Boston video, if they're really doing it, send me the link, please. Fanbase@mlittlelaw.com. Think they have a camera in the courtroom? I know it's the longest I've ever not spoken in my life. It's hard. It's really hard. Then we could get a better camera. And then I could talk. Hold on. I know. I don't know. Somebody said Boston 10 is on it, but then somebody said they're not. I don't know.
Yeah, whatever. I'm here all the time, so. I mean, we have a trial, unfortunately. We have a trial date, February 9th. Yeah.
I mean, actually, probably need to further define so much.
Okay.
Yeah, you just read in what you think and is there anything made later?
Yeah, I'm gonna just pass this off and ask her to endorse it as allowed, as
Yeah.
I gotta do the 14th. Okay. Oh, whenever. Okay.
That's another one. Yeah. I think we should probably do either week of the 5th or week of the 12th.
Yeah, either the end of the 5th. So early that week, any day except for the 14th. 13th? Doctor's appointment first thing, so.
Yeah, maybe 12 again or whatever.
Oh, good.
Great.
I told him to stay here because I thought they were gonna get it, but you can tell them to
No,
go
it looks like it's
If
okay.
not,
It's 25, so.
Yeah, just let them know.
Court will rise.
we have a
Court is objection be seated.
Calling number 20 on the list, Commonwealth versus Kelsey Fitzsimmons, docket number 2577 CR 311. Kelsey Fitzsimmons, docket number 2577 CR 311. Counsel, please identify themselves for the record.
Good afternoon, Your Honor. James Fitzsimmons, here on behalf of the Commonwealth.
Good afternoon, Your Honor. Martha Coakley for defendant Kelsey Fitzsimmons.
Hello, Your Honor, Tim Bradl, on behalf of Ms. Fitzsimmons, and for the record, we see Ms. Fitzsimmons on the.
Yeah. I did deny your motion. The reason is that I'm trying to be consistent with what I do here every day, which is not to transport people for scheduling days and for discovery motions. So I'm treating her the same way I'm treating everyone else. She's not being singled out either one way or the other.
We don't think so, Judge. We can forge ahead.
Yeah, we're very consistent in that regard. So any discovery issues that I can address again today, try to keep the case on track?
No, we worked it out. We have a discovery motion marked up. We just asked that you endorse it as a.
Sure.
Amendment.
Sure.
And Judge, where there's objections noted, we can defer those to another day and.
Sure.
And see how things turn out, in terms of compliance. And we were gonna be asking for January 13th for further compliance.
Sure. So I'm going to allow this as modified without prejudice to either side revisiting. Is that fair enough?
That's fine, Your Honor, yes. And Judge, maybe, it would make sense maybe for out-of-court compliance date for the discovery, and I defer to counsel on what that can be in the circumstances, but I would like to have some.
Well, give me 1 second. Sure. And what was the other thing you just said? I'm sorry.
So Judge, we just talked about a prior compliance date before the actual hearing date for the discovery. And counsel's asking for January.
Okay, so, and what's the other date you already have in, Mike, or do you want?
We want an out-of-court date. We can put out the record.
Fine.
You're never done for us to turn over everything that we agreed to, and then the 13th for in court.
We'll make that a trial readiness date. In other words, you can report to the court on the readiness, and hopefully on that date, and if there are any discovery issues, we'll work them out. If there are any Rule 17 motions, serve those on each other in advance so that everybody's had a chance to look at them. And I'll leave the trial date the way it is right now, and we'll go from there. The other thing I want to make it clear, if we bring people in for buccal swabs if it's necessary. If she wants to, for example, I know there's a controversy, if she wants to take the SCRAM again, if there's a reason to bring her, we would do that. So it's not, as long as there's a reason, we do it all the time for buccal swabs. We do it for evidentiary hearings. Those are examples of the types of things. So if there's a point in time in which that needs to be addressed, you can do that. Just give us some notice, that's all.
Thank you, Your Honor.
And anything else I can address today?
No.
All right, terrific. Happy holidays.
Thank you.
Thank you, Your Honor.
Take care. All right, thanks. Right now, Zoom the next date, unless there's a request for some other reason, we'll do that, okay?
Very good.
All right, thank you very much. Okay, and we have that.
Goodbye.
We still expect them to be. We think it's cool.
Shout out to law girls, not attorneys, who were broadcasting from the courtroom and have said that I can use their feed. So thank you to them, because that was a much better feed than the Zoom feed, although we did get to see Kelsey on the Zoom. Let's just take this back because I think it was hard to hear for some of you. That was Judge Drexler. This was just basically a status hearing. Hold on.
Ms. Fitzsimmons on the Zoom.
Yeah.
There's a trial readiness date on the 9th of January. Thank you to Law Girls Not Attorneys. Follow them on all socials. This was broadcast on Twitter. So I can't boost Twitter feed. I'm going to always call it Twitter. I'm sorry. It could have been done by Zoom, I know, but they got mad last time and they told him, Mr. Bradl and Martha Coakley, they had to appear in person for everything. Okay? I know you couldn't hear, so I'm going to play it again in my earphones and I'm going to tell you. So don't turn up your volume. I'll listen to it and tell you what happened. Basically, nothing happened.
On the last Commonwealth versus Kelsey Fitzsimmons, docket number 2577, CR 311. Counsel, please identify themselves for the record.
Good afternoon, Your Honor.
James
James Gubitosi on behalf of the Commonwealth.
Gubitosi on behalf of the Commonwealth.
Good afternoon, Your Honor. Martha Coakley for defendant Kelsey Fitzsimmons.
Hello, Your Honor. Timothy Bradl on behalf of Ms. Fitzsimmons.
Timothy Bradl and Martha Coakley for Kelsey.
For the record, we see Ms. Fitzsimmons on the Zoom.
Yeah. I did deny your motion. The reason is that
He denied their motion to allow Kelsey to be transported to court in person for this conference/hearing. This was supposed to be a discovery motion hearing. And he's explaining why, and I'll tell you why in a second.
try to be consistent with what I do here every day, which is not to transport people for scheduling days.
He said he has to be consistent with all of the other prisoners in custody, and that, if he lets her come and be transported 2 hours each way, he's going to have to do it for everyone.
Discovery motions, so I'm treating her the same way I'm treating everyone else. She's not being singled out either one way or the other.
She's not being singled out one way or the other because, I wouldn't allow anybody to be transported here from wherever they're holding for a discovery conference.
Thanks, Judge. We can forward that in an hour.
Yeah, we're very consistent in that regard. So Any discovery issues that I can address again today, try to keep the case on track?
Nope, we worked it out. We have a discovery motion marked up. We just asked that you endorse it as a.
Sure.
Amended.
Sure.
And Judge, where there's objections noted, we can defer those to another day and
Sure.
and see how things turn out in terms of compliance. And we were going to be.
The defense wants the Commonwealth to comply with their discovery demands. We went over their discovery demands, I think, on the last stream, and it seems that they have complied with some. And Tim Bradl says, give us another date so we can take a look and see if there's any objections to that.
Asking for January 13th for further compliance.
Sure. So I'm going to allow this as modified without prejudice to either side revisiting. Is that fair enough?
That's fine, Your Honor, yes. And Judge, maybe it would make sense maybe for out-of-court compliance date for the discovery, and I defer to counsel on what that can be in the circumstances, but I would like to have some.
Well, give me 1 second, sir.
If you rewind, you can see that she was on Zoom. It's 2 hours each way from Chicopee. I mean, I could see why they wouldn't transport her there.
And what was the other thing you just said? I'm sorry.
So Judge, we just talked about a prior compliance date before the actual hearing date for the discovery, and counsel's asking for January.
Okay. So, and what's the other date you already have in mind, or do you want?
We want an out-of-court date. We can put out the record.
Fine.
January 9th for us to turn over everything that we agreed to, and then the 13th for in-court.
We'll make that a trial readiness date. In other words, you can report to the court on the readiness, and hopefully on that date. And if there are any discovery issues, we'll work them out. If there are any Rule 17 motions, serve those on each other in advance so that everybody's had a chance to look at them. And I'll leave the trial date the way it is right now, and we'll go from there. The other thing I want to make it clear, if we bring people in for buccal swabs if it's necessary. If she wants to, for example, I know there's a controversy. If she wants to take the SCRAM again, if there's a reason to bring her, we would do that. So it's not, as long as there's a reason, we do it all the time for buccal swabs. We do it for evidentiary hearings.
Seems to me that he's saying if she wants to come back and try and do the SCRAM again to see if she's physically able to do it, they would transport her for that. That's what it seems like you just said to me. If she wants to come back because she's feeling better and she's able to do the SCRAM monitoring now, I'll transport her for that. Sounds like that could be her best way to get out of jail before Christmas. If she can do it, transport her, get her there on Monday, have her do it. Maybe he would change her conditions. And then maybe that's the fastest way to get her home for Christmas. That's the way I understood it. Thanks, Law Girls Not Attorneys, for doing the Lord's work. I want to hear that again. He said, we transport people here all the time for buccal swabs. That's when they swab the inside of your mouth for DNA. Or if she wants to try the SCRAM again, if she's physically able to do it.
I know there's a controversy.
Listen.
Make it clear if, we bring people in for buccal swabs if it's necessary. If she wants to, for example, I know there's a controversy. If she wants to take the SCRAM again, if there's a reason to bring her, we would do that. So it's not, as long as there's a reason, we do it all the time for buccal swabs. We do it for evidentiary hearings. Those are examples of the types of things. So if there's a point in time in which that needs to be addressed, we can do that. Just give us.
If there's a point in time that we need to do that. I don't know if he can touch it while it's still in the SJC's hands.
Some notice, that's all.
Thank you,
And anything else I can address today?
No.
All right, terrific. Happy holidays. Thank you. Take care. All right, thanks.
Terrific. Happy holidays. Thanks, Law Girls Not Attorneys. Please go follow them on all of the socials that you choose to wade into. And we are going to take a look at Disgustin' Justin's response to the motion for the grandparents to be able to see the baby boy. Now that the SJC has the issue on the SCRAM, I don't think that this judge can do anything. I could be wrong, but that's the way that I understand the court rules and the law of Massachusetts. That now that it's in the SJC's hands, this judge doesn't have any jurisdiction. That is why she's in jail. The reason that she's in jail is because it was too painful for her to do the SCRAM testing. She was required to do alcohol monitoring as one of her bail conditions. And the alcohol monitoring that was assigned to Kelsey Fitzsimmons is a device, a handheld SCRAM device that requires her to blow into a tube for extended periods of time in order to monitor her for alcohol use. 2 days after she was released by Judge Kathleen McCarthy Neyman, Tim Bradl made an emergency motion to come back and told the court it's very, very painful for her to do that. She can do it, but she can't do it without pain for hours afterwards because she was shot in the chest. She had a collapsed lung with requiring the insertion of a chest tube, a couple of broken ribs, and several other injuries that required something like 5 or 6 surgeries. She was in the hospital for 53 days. She was airlifted from the scene. And because of these injuries, it's very, very difficult for her to blow into this SCRAM device. The judge said, and when Tim Bradl brought up, this may be cruel and inhuman punishment for you to require this because of her injuries, the judge said, and even though the assistant chief of probation was there and testified, and there was evidence that other methods could be used that would not be painful for Kelsey, including urine testing. The judge said, oh, it's cruel and inhuman. Well, I don't want to do that to her, so I'm just going to put her back in jail. And there she has sat for all of these months. And now it is all at the highest level of the appellate court in Massachusetts, which is the full panel of the SJC. They did not issue a decision today. They've been reviewing it since December 2nd. And apparently they release decisions every day. I thought it was once a week, but they do it every day. And so we just don't know what's going to happen. And I don't know if their decision would be an automatic get out of jail or if it would be sent back to the lower court to decide to a new hearing. So the chances of her getting home for Christmas are pretty slim. And that is incredibly sad because she has not seen her baby since June 30th. And that's horrified. And you should be horrified. You should be horrified. But you might be more horrified when you read Justin's opposition to Kelsey's mother and stepfather's request to the court to have visitation with their grandson. So, here we go. I'm giving you a blanket trigger warning for this because it may outrage you to the point of, you might be throwing your coffee all over the place. This was filed on the 17th. Today is the 19th. This is Kelsey's mom and stepdad, Lauren Page and William Page. They petitioned the court, and the respondents are Justin Aylaian, who is the father of Kelsey's baby, her former fiance, her ex-fiance, and Kelsey. And this is respondent Justin Aylaian's verified motion to dismiss petitioner's petition for grandparents' visitation pursuant to Massachusetts General Law 119, Section 39D. Buckle up. Now comes one of the above captioned respondents, Justin Aylaian, hereinafter the father, who respectfully moves this honorable court, pursuant to Massachusetts Rule of Domestic Relations 12B6, to dismiss with prejudice the petitioners Lauren Page's, hereinafter Mrs. Page, and William Page's, hereinafter Mr. Page, petition for grandparent visitation pursuant to Massachusetts General Law 119, 39D, filed October 2nd of 2025. Okay, they filed this on October 2nd, and Justin is only responding now. It's stamped December 17th. No big whoop. You're also going to see in here that he takes a couple of pot shots at Kelsey's parents, which is kind of gross. You let me know what you think. Brief background and procedural history. So for those of you who are not familiar with this case, not only is there extensive show notes in the notes below this video, but also this is going to give you a bit of the procedural history and the dates that everything happened. The father and the second name responding, Kelsey Fitzsimmons, hereinafter the mother, were never married and have one child together. Namely, I'm going to call him baby boy Aylaian. His date of birth was February of 2025, and he's now 10 months old. The father and mother resided together with the minor child at a redacted address from the time of the minor child's birth until on or about June 30th of 2025. That was the date that Kelsey Fitzsimmons was shot by her co-worker, police officer Patrick Noonan, North Andover police officer Patrick Noonan, in the chest. The father presently resides with the minor child at his parents' home located at blank, which is in a different county. It's not in Essex County. Mother is currently being held without bail at the Western Massachusetts Regional Women's Correctional Center located in Chicopee, Hampton County, Massachusetts, pending a criminal trial on a charge for assault with a dangerous weapon upon a police officer in the Essex Superior Court. Well, I don't think that's the actual charge. The charge is not assault with a dangerous weapon upon a police officer. No, the charge is assault with a dangerous weapon. But they'll take any opportunity to just toss in some facts that they think might be good for them in the media in the Essex Superior Court. Mr. and Mrs. Page presently reside at blank address. On or about June 30th, 2025, the day of the shooting, the father sought and obtained an emergency abuse prevention order pursuant to Massachusetts General Law 209A from the Essex County Probate and Family Court, Judge Ulwick. Pursuant to the 209A order, the father was granted sole custody of the minor child, and the mother was ordered not to contact the father or the minor child. The 209A order remains active, and a two-party evidentiary hearing is scheduled for April 14th, 2026. That's not a typo. That's not a typo. That's 4 months away. He also doesn't mention here June 30th, the day that he went to court to obtain this restraining order. First of all, it was ex parte. Kelsey had no say. She wasn't there. She didn't get the opportunity to be heard. And the reason that Kelsey Fitzsimmons was shot in the chest by Officer Patrick Noonan is because Officer Patrick Noonan and two other male officers from North Andover PD went to Kelsey Fitzsimmons' house, she's also North Andover PD, to serve her with this order and rip her breastfeeding infant away from her breast, take her baby away, and serve her with this restraining order that Justin just obtained on his own that very same day. That caused Kelsey, for those of you who don't know, she has given a statement saying that she saw everything in her life flash before her eyes, her career, her marriage, her upcoming marriage, her engagement, and her child being taken away from her. In her mind, she had nothing left to live for. And so when she went upstairs to pack some things for the child, Noonan was with her. Kelsey says she took out her service revolver, or one of her weapons, and pointed it at herself, at which point she was shot in the chest by Officer Patrick Noonan. Noonan has a different story. Noonan says Kelsey pointed the weapon at him. Therefore, he took out his weapon and shot her in the chest. Important to note, the attempted murder charge, Kelsey was originally charged with attempted murder, went to a grand jury, and the jury refused to indict on that charge. So something just didn't sit right with a grand jury. And as you know, according to Saul Wackler, who was Chief Justice of the Appellate Court of New York, famously said, a good prosecutor can get a grand jury to indict a ham sandwich. Well, not the Essex County grand jury. Apparently they didn't fall for it. And so the only thing that Kelsey has been charged with is assault with a weapon, with a dangerous weapon, which carries a maximum 5-year prison term, but based on Kelsey's history, she would likely get probation and no jail time. Paragraph 7. On or about July 1st, 2025, which was the very next day after she was shot and airlifted to Massachusetts General Hospital. Those are my words. They're not in the papers, though. On or about July 1, 2025, father filed a complaint for custody, support, and parenting time pursuant to Massachusetts General Law 209C. And then he amended it on August 8th of 2025 in the Essex County Probate and Family Court. The mother was served with the summons and father's amended complaint on or about September 5th, 2025. Okay, was she ever served with the original complaint? Unclear, because Justin's papers don't address it. On or about July 3rd of 2025, mother was criminally charged with, remember this is different than an indictment, this is just what she was charged with while she was in the hospital. 1, she was fighting for her life at this point. I mean, this is 3 days post being shot in the chest. Mother was criminally charged with 1, armed assault to murder, 2, armed assault to murder. I think it was it should be attempted murder, but 2, assault with a dangerous weapon, and 3, assault with a dangerous weapon. Mother was arraigned on or about August 7th of 2025. Again, from her hospital bed. 9, on or about August 25th of 2025, mother was indicted on 1 charge for assault with a dangerous weapon. On or about August 28th, 2025, mother was released on bail to be set at personal recognizance. Actually, she wasn't actually released that day, but let's keep reading. The conditions of mother's release were as follows. 1, GPS in place. 2, 24/7 house arrest except for medical court attorney visits with 48 hours notice to probation. And 3, reside with her mother, Lauren Page, and stepdad, William Page, at their home. No weapons in home, and Corey checks on all people in the home. A Corey check is a criminal background check. 4, stay away, no contact with the victim or with the child. 5, no alcohol with SCRAM. That's the handheld device I was telling you about earlier. 6, sign any and all releases. And 7, follow treatment plan issued by Massachusetts General Hospital. On or about September 11th, 2025, because that's how long it took them to do the Corey checks on everyone in the house. The Essex County Superior Court, Judge McCarthy Neyman, issued an order which, in part, vacated the court's prior order of release and ordered that mother be held without bail pursuant to Massachusetts General Law 276. Well, a couple things happened in between. First of all, she was not released on bail on August 28th. We know that because we've been here the whole time. I believe, and you can correct me if I'm wrong, that she was not actually released until September 8th of 2025. And then when it was determined that it was too painful for her to blow into the device, she filed an emergency motion. First, she asked the court, would it be possible to have my ankle monitor installed tomorrow after my surgery? Because I have to have surgery tomorrow. I think it was her 6th surgery. I think this one was for a lacerated liver. And the judge said, no. Because, doctors won't even do surgery if you have earrings in. And then Tim Bradl made an emergency motion because it was too painful for her to do the SCRAM alcohol monitoring, as I described to you earlier. And so after she was released on September 8th, she was home for, 48 hours or so until she was thrown right back in jail from the hearing. And we listened to the audio of the hearing, and it was chilling. It was chilling. We could hear Kelsey wailing at the end as they decided to put her right back in jail. Mother's criminal jury trial is currently scheduled for February 9th, 2025 in the Essex County Superior Court. On or about October 2nd of 2025, Mr. and Mrs. Page filed a petition for grandparent visitation pursuant to the Massachusetts general law, an affidavit of Mr. Page in support of petition for grandparent visitation, an affidavit of Mrs. Page in support of petition for grandparents visitation, and a motion for temporary orders. On or about October 28th of 2025, the court, Judge Black, entered a temporary order in mother and father's pending 209C matter, which incorporates the stipulation for temporary orders on plaintiff's verified motion for temporary orders dated October 22nd, 2025, and states in pertinent part as follows. And we went over this as well. Hold please for 1 second. Remember, these temporary orders were based on a stipulation between the attorneys. It is always better, in my opinion, to reach an agreement with the other side if you can, especially in family court matters, because you don't want a judge who doesn't know anybody to rule on your family's future if you can agree on it yourselves. And so this was a stipulation. A, the father shall have legal and physical custody of the party's minor child. B, the mother shall have no parenting time. C, father will share updates about the minor child, such as his diet, general well-being, development, medical and dental appointments, new activities, discoveries, evolving likes and dislikes, milestones, for example, first steps, first words, as well as photographs and or videos of the minor child, to the father's counsel of record on the 15th and 30th of every month. Father's counsel shall share the same with mother's counsel within 24 hours of receipt of same. D, if and or when the minor child is baptized, the father shall ensure that the ceremony is video recorded. The father shall send father's counsel the video of the baptism that same day, and the father's counsel shall forward the same to mother's counsel. The parties agree that the mother's sister may attend the baptism. It's important to note, I'm breaking from the document for a second to tell you that I believe Kelsey's sister, it had been agreed between Justin and Kelsey that Kelsey's sister was going to be the godmother of the baby boy. On or about November 13th, 2025, Mr. and Mrs. Page filed a request for status on motion for temporary orders. So the court did nothing from the time that they received the petition filed on October 2nd until November 13th. And so Mr. and Mrs. Page filed a request to the court like, hello. Sometimes we need Cardi B. Why are you not even scheduling a date or doing anything? On or about November 13th, on or about November 26th, 2025, the father was served with the summons on the petition for grandparents visitation pursuant to the Massachusetts general law. And so I don't know if he had never been served. It's unclear. Or if he was served again. Or if they tried to serve him and they couldn't. But every now and then.
Hello. Hello.
Every now and then we need Cardi B because she will never not be funny to me. And this is tragic. And sometimes we need to laugh. Otherwise, we're just going to cry. I've pinned Kelsey's fundraiser in the chat. If you feel like you're in the giving mood, every dollar counts. Here's Justin's argument. Pursuant to Massachusetts rule of domestic relations, the court has the authority to dismiss a complaint when the moving party has failed to state a claim upon which relief may be granted. A complaint must include factual allegations plausibly suggesting, not merely consistent with, an entitlement to relief. Massachusetts does not recognize grandparents' rights. Many states don't. I saw something in the chat saying, in what world would the grandparents not be legally able to see the baby? That's a great question, Melissa. But many states do not recognize grandparents' rights. People in the chat will tell you they've tried to fight for them. And in Massachusetts, not so much. It's difficult. Point A, the petitioners lack standing. Pursuant to the Massachusetts general law, grandparents may petition the court for visitation if the minor child's parents are either deceased, unmarried, divorced, or married and living separate and apart. While the general law does not explicitly define the term grandparent in quotes, the Massachusetts Appeals Court has held that in regards to the requests for visitation by a person other than the biological grandparents of a child, the probate court has the authority to exercise its equity jurisdiction and order visitation by a person who does not have standing under the general law. As such, the case law is clear that the Massachusetts general law relates to biological grandparents only. And this is citing a case from 2001. Mr. Page's affidavit, which he signed under the pains and penalties of perjury, alleges that he is the quote maternal grandfather of the minor child. Furthermore, the motion for temporary orders filed and signed by Mr. and Mrs. Page on or about October 2nd, 2025, alleges that they are both, quote, the biological grandparents of the minor child. Mr. and Mrs. Page are audaciously attempting to mislead this honorable court. You can tell me at the end of this reading who you think has the most audacity. I'll leave that to you. Mr. Page is not, in fact, the minor child's maternal grandfather. Mr. Page is merely married to Mrs. Page, is not mother's biological father, and is therefore not the minor child's biological grandfather. Mr. Page's marriage to Mrs. Page does not grant him the legal right or standing to petition this court for visitation with the minor child and invade the father's constitutional right to make decisions regarding the care and upbringing of his child. See Blixt, be Blixt, 2002, noting that any third party should not be permitted to seek visitation. Furthermore, mother's biological father, and therefore the minor child's actual maternal grandfather, is very much alive. Mother's biological father is named Mr. Stephen Fitzsimmons. It also should be noted that Mr. Stephen Fitzsimmons may live in a different state and may live some distance away from North Andover. But Justin doesn't say that. Let's listen to what Justin does say. Before the father sought and obtained the 209A order against the mother on or about June 30th of 2025, and since the minor child's birth in February of 2025, Mr. Fitzsimmons visited the mother and father on several occasions to perform maintenance on the house. While Mr. Fitzsimmons was present, the mother intentionally avoided Mr. Fitzsimmons and eventually instructed him to refrain from visiting the house. Well, that's not hearsay upon hearsay upon hearsay. Listen to how he throws shade on Kelsey's parents. Yes, the biological grandparents of his son. Mr. Fitzsimmons, the minor child's maternal grandfather, who has held the minor child approximately 4 times, has not petitioned this court for visitation. Let's keep going. Given that Mr. Page is not the biological maternal grandfather, he does not have standing to petition the court for visitation pursuant to the Massachusetts General. And he may be right. That may be true. That may be true. But that doesn't mean that Kelsey's mother is not entitled to visitation. So let's keep reading. B. The petitioners failed to meet, failed to meet the heightened pleading requirements required by Blixt v. Blixt. A lot of people in the chat are saying this is emotional abuse. I'm not a mental health professional. I'll leave it to you. 1, the father has a constitutional right to make decisions regarding the care and upbringing of his minor child. The U.S. Supreme Court has long recognized that a parent has a due process right to make fundamental decisions concerning the care, custody, and control of their children. The analysis, that's a 2000 case from the U.S. Supreme Court called Troxel versus Granville. The analysis must be guided by the liberty interest at issue, the interests of parents in the care, custody, and control of their children, which is perhaps the oldest of the fundamental liberty interests recognized by this court. The burden of litigating a domestic relations proceeding can be so disruptive of the parent-child relationship that the constitutional right of a custodial parent to make certain basic determinations for the child's welfare becomes implicated. The Massachusetts Supreme Judicial Court has consistently reaffirmed that, quote, the decision of a fit parent concerning grandparent visitation is entitled to considerable deference. There is no question here relative to whether father is a, quote, fit parent. Well, you better want what you wish for sometimes. When you start opening doors like this, could lead to a whole Pandora's box of worms that you might not want to get into. And so let's keep going. Pursuant to both the 209A order dated June 30th, 2025, and this court's temporary order dated October 23rd, 2025, the father has sole legal and physical custody of the minor child and mother has no parenting time. Yeah, that's right, because she's in jail for no good reason, in my opinion. Further, as part of mother's criminal matter pending in the Essex Superior Court, mother was ordered to stay away from the minor child. Notably, after father sought and obtained the active 209A order, that in Massachusetts, a 209A order is a restraining order in a domestic case. Typically DV cases, but it was used in this case as well. Notably, after the father sought and obtained the active 209A order against the mother on June 30th, 2025, the Department of Children and Families opened an investigation. However, the case was closed shortly thereafter based on the father having sole custody and the mother having no contact with the minor child. Oh, okay. So the DCF didn't investigate you and your family at all? Okay. Keep in mind also the standard for custody and other things involving children in family court is always what is in the best interests of the child. The best interests of the child is supposed to be paramount in family court matters, at least where I come from, at least where I practice in New York. Beery Cat says this is all based on a bogus 209A. Seems that way to me. As such, the father's decision to deny Mr. and Mrs. Page visitation with the minor child at this time must be given presumptive validity and considerable deference. Yeah, Tiff is here. She says, unfortunately, everything I want to say goes against all the YouTube rules. So I'm here listening, saying all the mean words. Love you all so very much. There's also something called parental alienation, which many of you might be familiar with. Unless we not forget, he lives with his parents, Justin does, in a different county. Back to the documents. To succeed on their petition, Mr. Page and Mrs. Page must rebut the presumption that the father's decision not to grant them visitation with the minor child at this time is in the best interest of the minor child. Number two, please refrain from cursing in the chat because, YouTube scans it. They don't like it. And just, try and be creative in your spellings. Thank you. The Massachusetts Supreme Judicial Court has established that petitioners in a petition for grandparents' visitation pursuant to the Massachusetts general law are subject to a heightened pleading standard. In Blixt v. Blixt, the Massachusetts Supreme Judicial Court, hereinafter SJC, set a standard that petitions for grandparents' visitation filed And here's an interesting comment that I'm just going to star for later. Hold on. Hannibal 65 says, why is no one curious as to what she may have done to cause him to do this? No curiosity at all? Weird. Are you saying she may deserve it? Are you saying that? I mean, are you saying that a mother deserves to have a breastfeeding infant ripped away from her bosom and be thrown in jail because of one judge's determination that she couldn't be urine tested for alcohol monitoring? She's already agreed not to have any contact with the child. She's not going to have any contact with the child, but I don't even know how to respond to this. You go on with your bad self. If you've got some inside information, Hannibal, please be sure and let us know. And toxic relationships, right, Kippy Hippie, sometimes they're both people. It's not always just one person's fault, but that doesn't take away your right to be a parent. Something happened before the police showed up. Well, Justin wasn't at the house. No, I'm asking. Like you're asking. I don't know. There's a lot that's going to come out here. Maybe you're not familiar with the case, and if that's the case, then I'm sorry. But what happened before the police showed up is that Justin went and got an order to take her baby away and a no contact order. What happened was they were at a bachelorette party a couple of days before for Kelsey in Maine, and Justin was there too. And he says she drank too much and got mad. And apparently they were living together, and quite possibly she broke up with him and kicked him out. And that may be what angered him so much that she kicked him out. Maybe she called up the engagement. I don't know. I wasn't there. And he told her, right? Justin told her to meet him at a park, and she waited there for 2 hours with the baby, and he never showed up. But we have read all of the papers, and all of the papers, Justin's side of the story is Kelsey got drunk at her bachelorette party, and I was in fear that she would do something to me or the baby. I was in fear. His entire side of the story is in all of the previous shows that I've done. So if you want to go back and watch them, it'll tell you in his own words. There's a whole Kelsey Fitzsimmons playlist. Maybe she broke up with him. Maybe she called off the wedding. She owned the house that they lived in. Maybe she kicked him out. Yeah. Right. She was forced to sell her house, right? She was forced to sell her house because another thing that Justin did was make a motion because her house was on the market because she needs to sell her house. It was only in her name. He made a motion to obtain all of the proceeds from the house and for future child support that hasn't even been determined yet. So everything that Justin has done makes me call him disgusting Justin, because he's just in it for the money. My opinion. All of his actions, all of the court documents that we've read were all about money. And luckily, the court did not grant that motion for him to obtain the entire proceeds from the sale of Kelsey's home, which I think has been sold. Maybe she was afraid of him. But you know what? We don't know, because we haven't heard Kelsey's side of the story yet, because they just took her baby away and granted his restraining order without her having the opportunity to be heard, which is a constitutional violation. Think about that. If somebody can go into court and based on their story alone, can take your baby away from you without you getting to tell your side of the story in court, you should be, the bejesus should be frightened out of you. Wow. Does YouTube really have time to read all your chats? I don't know. They have AI programs that scan everything, though. They do. Just ask Linda Kenny Bodden and Michael Bryant. They know. They've had stuff taken down. I know. It's strange we haven't heard her side, but she hasn't been able to appear yet. They haven't even scheduled a hearing on this until April of 2026. That's the problem. That's the problem. Here we go. In Blix v. Blix, the Massachusetts SJC set a standard that petitions for grandparents' visitation filed pursuant to the law are subject to a heightened pleading standard. Before a parent or parents are called upon to litigate a fully a grandparent visitation complaint, with all the attendant stress and expense, the grandparent or grandparents should make an initial showing that satisfies a judge that the burden of proof can be met. To this end, any complaint filed under the statute should be detailed and verified or be accompanied by a detailed and verified affidavit setting out the factual basis relied on by the plaintiffs to justify relief. Accordingly, to survive a Rule 12 motion, a Blix affidavit must contain averments of significant harm that are 1, facially sufficient to rebut the presumption of parental fitness, 2, based on information and belief, and 3, made with particularity and indicating the source of the information. This quote showing of significant harm may arise either 1, in the context of a significant pre-existing relationship, or 2, in the absence of such relationship. A grandparent may prevail only by showing that visitation is nevertheless necessary to protect the child from significant harm. Even assuming that Mr. and Mrs. Page have proper standing to petition the court for visitation, for the reasons set forth below, their petition and affidavits fail to meet the heightened pleading standard imposed by the SJC and must be dismissed. 1, the petitioners fail to allege a pre-existing significant relationship. You remember, baby boy Aylaian was 4 months old. At the time, he was ripped from his mother's arm and she was shot in the chest and airlifted to the hospital. Quote, in imposing the requirement of harm in the context of a significant pre-existing relationship, the court meant, quote, and this is all in bold font from here on, the kind of relationship such as de facto parents or other relationships of close bonding where significant harm may be readily inferred from and is inherent in the disruption of that relationship. The petitioner's affidavits, which were signed under the pains and penalties of perjury, are riddled with inaccuracies and false narratives. Riddled with inaccuracies and false narratives. Ready? Notably, the minor child was only 4 months old when the father was granted sole custody on June 30th, 2025, pursuant to the 209A order. The minor child is currently 10 months old. Right, and also, I'm breaking for a second to say, if Kelsey wasn't shot in the chest on June 30th of 2025, airlifted to the hospital where she remained for 53 days, perhaps she would have had the opportunity to be heard in court. But the events that unfolded on the day when this guy went in and got his ex parte order to take the baby away and the stay away order from Kelsey resulted in this unfortunate series of events, a series of unfortunate events. Mr. Page's allegation that he provided financial and emotional support and has been, quote, a source of stability, guidance, and family continuity, end quote, to an infant is underlined, during the first 4 months of his life is absurd. Further, it is curious that Mr. Page felt inclined to include in his affidavit, which must include averments of significant harm that are, quote, facially sufficient to rebut the presumption of parental fitness and be made with particularity, that he has provided financial support to the minor child. Why is that curious? Because it makes you look like less of a man and not being able to provide for your family. Justin Aylaian is a North Andover firefighter, by the way. I think they make pretty decent money. I don't know. But I think that Kelsey made more money than Justin did. And this is cruel. You're right, Pauline. This is cruel, beyond cruel. Even if that were true, it is perplexing how providing mere financial support could support a finding of relationship that should be considered similar to a de facto parent. Similarly, Mrs. Page's allegations that she, quote, regularly cared for the minor child, end quote, and that the minor child, quote, was very accustomed to our presence and care, end quote, and that they have a, quote, strong bond, end quote, is perplexing, given that Mr. and Mrs. Page were only present during the first 4 months of the child's life. Right. Because then you got a court order to take the baby away. And maybe Kelsey's in jail exactly where you wanted her, because she was supposed to go back to work. She was cleared to go back to work with North Andover PD for July 4th. This happened on June 30th. I believe that the bachelorette party was on something like June 28th, right? 2 days before. Hell hath no fury like a fiancé scorned. Justin. Craftastical says, serious question. Why would Kelsey want to shoot Noonan? Any logic to claiming that? Right. I don't know. Maybe because why didn't the grand jury believe Noonan's testimony? And we also know there's no bedroom door. Remember, Noonan testified that she ducked behind the bedroom door, came out with her weapon and pointed at him. There is no bedroom door. There are no doors in the bedroom. And Craftastical says, makes no sense, but Kelsey's story does. Thanks for the updates. Oh, please. Right. So creating through chaos says, so basically they want to cut Kelsey and the family right out of the baby's life. Exactly. Given that the minor has not seen Mr. and this is, this was more important to me, so I highlighted this part in pink. Given that the minor child has not seen Mr. and Mrs. Page since he was 4 months old, it is highly unlikely that the minor child would even recognize them, let alone be very accustomed to their presence and care. Further, Mrs. Page sets forth 0 averments of significant harm that are made with particularity that support her allegation that a, quote, disruption between her ability to spend time with the minor child would cause unnecessary emotional stress and developmental harm. Grandparents, if your heads are popping off, I don't blame you. Further, given Mrs. Page's alleged concerns, it's perplexing that she and Mr. Page waited approximately 3 months after the father was granted sole custody of the minor child to file this petition. I'm not going to make excuses for Mr. and Mrs. Page. I'm just going to point out some obvious facts. Mrs. Page's daughter, Kelsey Fitzsimmons, was fighting for her life in the hospital. Fighting for her life in the hospital for 53 days and underwent 5 surgeries. I don't remember from their petition, we read their petition. I remember we read their petition. I don't remember if they filed it pro se or if they filed it with an attorney, but perhaps they had to gather funds for an attorney. Perhaps they thought Kelsey was going to be released on bail because on August 28th, they were told that she was going to be released on bail and that she was going to be able to come and live with them. And so their focus was on caring right then for their daughter and stepdaughter. Further, given Mrs. Page's alleged, right, so there it is, 3 months. According to the motion for temporary orders filed on October 2nd, 2025, Mr. and Mrs. Page alleged that they have a long-standing relationship with the child. From February of 2020, here's where it gets specific. From February of 2025, the minor child's birth, to June 30th of 2025, the date that father was granted sole custody of the minor child pursuant to the 209A order, and also the date that Kelsey Fitzsimmons was shot in the chest and airlifted to the Massachusetts General Hospital. The father and mother rarely brought the minor child over to Mr. and Mrs. Page's home. Mr. Page rarely, if ever, went to the mother and father's house to see the minor child. Mrs. Page would occasionally stop by on her way home from work, approximately 2 times per week, for 1 hour to see the mother and the minor child. Additionally, during these 4 months, Mr. and Mrs. Page babysat the minor child for a few hours on 2 to 3 occasions while the father and mother went on a date or spent time with friends. Let me point something out to you. Let's use our context clues. Mrs. Page works. She has a job outside the home. So the fact that she could occasionally, the fact that she could stop by on her way home from work twice a week for an hour, I'm sorry, is it not enough to establish a relationship with an infant? Number 2, I know parents of children who didn't even go on vacation until their kids were 10 years old, would never leave their kids with anybody. Some grandparents never babysit the children. How many times did Justin's parents babysit the children? Because now he's living with them. And so sometimes during the early infant stage, especially if you're breastfeeding, you don't really want to go out that often. But remember, it was Justin's idea to bring the baby to a brewery to meet his friends. Remember that? We read that in some court papers somewhere. The father and mother rarely, if ever, left the minor child alone with Mr. and Mrs. Page for more than a few hours. Furthermore, the minor child has never stayed overnight at Mr. and Mrs. Page's home, as given Mrs. Page's excessive alcohol use. Well, isn't that interesting? You're going to take this opportunity to throw in some complete and total hearsay that you think that Kelsey's mother drinks too much. And doesn't that tie in nicely with the alcohol conditions imposed on Kelsey, even though this incident involving Noonan had nothing to do with alcohol? But sure, throw it on in there. I'm going to read that again. Furthermore, the minor child has never stayed overnight at Mr. and Mrs. Page's home, as given Mrs. Page's excessive alcohol use. The mother and father previously agreed not to allow the minor child to stay overnight at their residence alone. You're right. The court did investigate the family. Irish poor face Mima. They did. A different court. Right? It was the Superior Court. They investigated her family before they would let her go live there. But this is in the Probate and Family Court. I don't know, I could take a poll in the chat, but those of you with infants up to 4 months old, did you ever let your infant stay overnight with grandparents or anyone within the first 4 months of your infant's life? I didn't. Hold on a second. Oh, please. Block Island is so nice this time of year. Have you guys ever been? Let me know if you've ever been to Block Island. It's a lovely island in between Massachusetts, Rhode Island, and Long Island. It's lovely. It's really lovely. Just thought I'd point it out. And common sense investigator says it's hilarious to me, given that Justin drinks like a sailor, in her opinion. But once you start bringing out the guns, it's probably not a great analogy. Once you start bringing out the guns, accusing everybody of drinking too much, you better be prepared for the opposition on this. I don't know who else lives in the house with Justin and his parents, but we do know about the parents' history. And we do know that the parents have taught other people how to get their family members involuntarily committed to drug rehabs, what to do, how to do it. So you better be ready for the opposition on this. Hope his attorneys are aware of some of the stuff that could be going on in his family. More hearsay. A mother and father previously agreed not to allow the minor child to stay overnight at their residence alone. I wonder what Kelsey would say about that. Both affidavits allege that Mr. and Mrs. Page saw the child every Sunday from February 2025, the minor child's birth, to June 30th, 2025. The date father was granted sole custody of the minor child pursuant to the 209A order, and the date that Kelsey was shot, I'm adding, and airlifted. To be clear, there were in total 19 Sundays between February 16th, 2025 and June 30th of 2025. Upon information and belief, the father and mother brought the minor child to Mr. and Mrs. Page's residence for Sunday dinners for 2 to 4 hours on approximately only 6 of these Sundays, which is less than half of the Sundays covering this period. Mr. and Mrs. Page's affidavits grossly misrepresent the time they actually spent with the minor child. Mrs. Page falsely alleges that she saw the minor child almost every day from the day he was born to June 30th, 2025. The date again. Even if that were true, that amounts to less than 50% of the entire duration of the minor child's 10-month life. I mean, do I need to keep pointing out the obvious? Because Justin has chosen to keep the baby away from them for 50% of the baby's life? As such, the minor child has spent the overwhelming majority of his life without Mr. and Mrs. Page's involvement, right? Because the minor child was with his breastfeeding mother that entire time. The misrepresentations and inaccuracies alleged in Mr. and Mrs. Page's affidavits do not stop there. Mr. and Mrs. Page also allege that father has ignored their requests for updates on the minor child's well-being and for pictures and videos of the minor child. On or about August 27th of 2025, 1 month before Mr. and Mrs. Page filed the petition, the father, through his mother, sent a picture of the minor child to Mrs. Page along with a general update. Mrs. Page responded, "Thank you so much for the picture and update." Furthermore, on or about October 3rd of 2025, before the father was served with the instant petition or was even aware of it for that matter, the father, through his mother, sent another picture of the minor child to Mrs. Page along with a general update. Okay, well, she responded to the first one. Did she respond to the second one? He doesn't say. Mr. and Mrs. Page's flagrant attempt to mislead this court is instructive on their credibility, and their allegations cannot reasonably be said to be facially sufficient. Even if the allegations contained in the affidavits are presumed to be true and the court draws every reasonable inference in favor of the petitioners, the relationship alleged by Mr. and Mrs. Page does not give rise to a significant pre-existing relationship. Yeah, 2 whole pictures, Becky says, in 6 months. Well, actually, it was in 4 months, less than 4 months, because it was between August and October. But yeah, I guess there's 6 months since then, right? Massachusetts courts have thoroughly considered grandparent-grandchild relationships. In Frazier, the Massachusetts Appeals Court held that where the petitioners alleged that the parental grandparents had over the years enjoyed many activities where the petitioner's rights alleged that the paternal with the children, including lunches, dinners, and visits, and spent time with them over meals and holidays, such allegations do not suggest the type of relationship with the children, plausibly suggesting a right to relief. Similarly, in Dearborn, the Massachusetts Appeals Court held that where the petitioner alleged that they saw the children regularly several times per month on average and liked to take the children to local fairs and on 2 occasions for camping trips, and his contact with the children was a mix of grandparenting and providing sitting for the children while their mother was involved in other activities and provided emotional support to the children, the relationship was a not uncommon one between grandparent and children. And while meaningful and nurturing, it is not the kind of relationship from which significant harm may be inferred from disruption alone. Mrs. Page's affidavit alleges that my daughter and her fiancé would come to our home every Sunday for family dinner. My husband and I also regularly cared for our grandson to allow them to spend time together as a couple, including evenings out. Mr. Page's affidavit alleges that he regularly saw the minor child multiple times a week and every Sunday for dinner, as well as provided financial/emotional support. These allegations describe and only permit the inference of a relationship wherein Mrs. Page occasionally visited the minor child. The parents of the minor child brought the child over for the occasional Sunday dinner, and the parents intermittently relied on Mr. and Mrs. Page for childcare. He's admitting here that they relied on Mr. and Mrs. Page for childcare. Where were his parents? That's an admission. Why did they need to rely on Mr. and Mrs. Page? They had nobody else to rely on. That's very telling. Neither petitioner alleges that the minor child ever resided with them or that they substantially contributed to the care and upbringing of the minor child. They simply enjoyed visiting the minor child when his parents brought him over and occasionally babysat him when his parents needed them to. There are no allegations or inferences therefrom which could plausibly suggest that it is, quote, the kind of relationship such as de facto parents or other relationships of close bonding where significant harm may be readily inferred from and is inherent in the disruption of that relationship. In other words, Mr. and Mrs. Page's relationship with a minor child was a, quote, not uncommon one between grandparent and child, and is not the kind of relationship from which significant harm may be inferred from disruption alone. For these reasons, Mr. and Mrs. Page have failed to allege significant harm in the context of a significant pre-existing relationship sufficient to survive a Rule 12b6 motion. Well, I'd like to know how many of the cases that they cited have to do with infants. 2, the petitioners failed to sufficiently allege that visitation is necessary to protect the child from significant harm. Well, I'm sure they will shoot back with whatever information they have about any significant harm that they feel the child might be in by living with Justin, his parents, and whoever else lives in that house. because maybe they didn't want to bring that stuff up in their initial papers because maybe they were being classy about it. But I guess all bets are off now. And again, they go on to cite the same cases that they keep on citing for the same proposition that they keep on citing them. The significant harm in the absence of a significant pre-existing relationship. Absent some extreme circumstance, the proper consideration is whether the petitioners made adequate factual allegations to plausibly suggest beyond mere speculation that visitation is necessary to protect the child from significant harm. Mr. and Mrs. Page's affidavits do not contain averments of significant harm that are facially sufficient to rebut the presumption of parental fitness or made with particularity and indicating the source of the information. I don't know. There are court records in New Hampshire where perhaps Justin was arrested for something involving something, possession of something at one time in the past. So I'm sure that the Pages will be opposing this motion to dismiss with everything they know. And all kinds of hearsay, because this is a whole bunch of hearsay too, right? And going on and on and on. Mr. Page says, denial of visitation would cause harm to the minor child's emotional well-being, but he fails to state with any level of specificity how the well-being and development would be or has been harmed without the requested visitation. He didn't plead any facts. That visitation is necessary to protect the child from significant harm. Similarly, Mrs. Page's affidavit alleges that she believes disruption may cause unnecessary emotional stress and developmental harm, and that the requested visitation is vital to the minor child's emotional well-being. Mrs. Page is merely speculating that a disruption in the minor child's relationship with Mr. and Mrs. Page may have negative consequences to the minor child. Mrs. Page's allegations fail to state with particularity how the minor child's development would be harmed by a disruption in their alleged relationship, and fails to include any adequate factual allegations to plausibly suggest, beyond mere speculation, that visitation is necessary to protect the child from significant harm. Finally, the affidavits fail to address the fact that since father was granted sole custody over 5 months ago, the minor child has been and currently is thriving. Well, that's wonderful. How would they know? How would they know? Because your mother sent them 2 pictures of the baby? The father and the minor child's medical providers have zero concerns relative to the minor child's emotional well-being, development, and safety. The father has enrolled the minor child in early intervention through which he is ensuring that all developmental goals are met. I'm sorry, why does a baby... this is a 10-month-old is in early intervention for what? Did you attach any medical records, any letters from a doctor? Because letters from a doctor seem to be really, really, really important in Massachusetts. Really important. Thriving is subjective, yes. The baby goes to daycare. Okay, so that's the early intervention. You're sending a 10-month-old to daycare? Who's watching the baby when you go on your 24s? I don't know. Do North Andover firefighters do 24s? Every firefighter that I know, from FDNY does 24s. Who's watching the baby when you're doing 24s? Does your baby go to 24-hour daycare? If he's suggesting that early intervention is daycare, that is a gross misstatement. Early intervention to me indicates some sort of special needs, developmental delays. That's the first that we're hearing of this. The court need not accept, quote, bald assertions, unsupportable conclusions, paraphrastic circumlocutions, and the like. Early intervention. Megan says early intervention is only given when a pediatrician recommends it, like a referral to a specialist. Right. Is that what he's referring to, though, or is he referring to daycare? That's why I'm confused. Neither Mr. or Mrs. Page filed a detailed and verified affidavit setting out the factual basis relied on by the plaintiffs to justify relief. Instead, the petitioners rely on speculation, conjecture, bald assertions that a denial of visitation would result in significant harm to the child, which is easily rebutted by the fact that the minor child is currently and has been healthy and flourishing. For these reasons, Mr. and Mrs. Page have failed to allege visitation is necessary to protect the child from significant harm. Right. Thanks, Deborah. Early intervention is for developmental delays. Oh, Deborah, did you get my email to send me just the information that you have so that I can refund you that mistaken super chat? Because maybe it wasn't you that wrote to me, because I wrote to you and you didn't write back. Conclusion. For the foregoing reasons, the case law is clear that the relationship alleged by Mr. and Mrs. Page is not the kind of relationship, such as de facto parents or other relationships of close bonding, where significant harm may be readily inferred from and is inherent in the disruption of that relationship. Mr. and Mrs. Page's affidavit in no way indicate that a failure to order visitation would subject the child to any harm, much less significant harm. It's very repetitive. Right. Justin Aylaian's PR firm, what an excellent username, says the child needed early intervention from being ripped from his mother's breast. As such, the petition fails to set forth allegations plausibly suggesting a right to relief for any claim under Iannuccino, let alone meet the heightened pleadings requirement of Blixt. Therefore, the petition must be dismissed. Wherefore, the father respectfully moves this honorable court to allow the respondent, Justin Aylaian's verified motion to dismiss petitioner's petition for grandparent visitation pursuant to the Massachusetts general law, and grant the relief requested herein, along with such further orders as this court deems meet and just. XOXO, just in it for the money, Aylaian. Discussed in Justin, dated 12/15/25. Follow the money. Always say follow the money, don't I? And this is submitted by his law firm. Cashco, Weissman, and Colasanti. And here's a proposed order saying they want it dismissed with prejudice, meaning they can never, ever ask again. They can never, ever ask again for visitation. That's what he wants. You guys are mad. I know you're mad. I feel your outrage. Right before Christmas. Yep. Right before Christmas. Tells you a lot, doesn't it? Doesn't it tell you a lot? Massachusetts, MassDad says pronounced Kaiko. Thank you. Kaiko? Kaiko. K-A-J-K-O is Kaiko. Thank you. You guys teach me something every day. Let's go to the chat because I know you're mad. Be truth, live factually. Thank you for becoming a member. I appreciate you. Aunt BB, thank you for your 10. Says Queen Mel, boy, you're fast. Imagine my horror to learn YouTube blocked me. Thank you so much for fixing it within 15 minutes. You're truly the best. And BB, you were my first member ever when I opened memberships on this channel. And you're my first member ever. And I love you so much. Thank you for your 10. On top, thank you for your super sticker. You're the greatest. Gypsy's been here for 5 months and says, yay, happy you're here. Thank you. Mama Cat said, and I'm whispering too, but I'm not on the Zoom. Thank you so much. The judge did not approve this yet. I'm sorry, Susan, if you're behind, or this is a motion by Justin to deny the grandparents' visitation rights. It has not yet been decided. This is what he's asking them to do. We were all whispering. Thank you very much for your 10. Ms. 808 says Bradl is 5 miles away, having to shout over his siblings. It's crazy. Thank you for your 5. Daria from Massachusetts says, thank you very much. That Broken Baker's having a fundraiser tomorrow from 12 to 6. What? A 12-hour fundraiser for Kelsey. Thank you very much for letting everyone know. Go on over there and support. Casey Paralegal says, when the system protects itself instead of the truth, justice becomes optional, and that should terrify all of us. Free Kelsey. Thank you for your 5. On top, thanks for your 5, says, if he was a slight bit honorable man, he'd allow the grandparents to see and bond with the baby. This clearly shows his many motives since this began. Right. He could disagree to let them see the baby, but for some reason, he just doesn't want to. Just a normal mom says, this makes me so angry. Thanks for being here for 14 months. And Denise has been here for 17 months. And she says, I'm not sure what, but hi, Denise. Thanks for being here for 16 months. JPS, Justin's behavior will backfire on him. Mark my words. When baby boy gets older and learns how his dad kept his mom from him, mark my words. These are all public court papers, right? Thanks for your 10. Aunt Bibi says, let's face it, cupcakes. They're dragging this out. So when Kelsey and the parents are able to see the baby, he's not going to remember them. How loud can I scream? This is sickening. Right. Who's driving that train? Who's driving this train? Robin says it's his parents driving this train. Who's driving this train? Thank you for your 10, Aunt PB. And Susan, thank you so much for gifting 5 memberships. You're amazing. And to the randomly gifted YouTubers in the chat, welcome. Thank you, Susan. Under your scars says, sick, who can we write to or petition? You can donate to Kelsey's fund. I wouldn't advise you to complain against anybody or write to anybody at this point. It's not ethically something that I can do as an attorney, but if you choose to help Kelsey, write her a letter. The address for Kelsey is underneath in the show notes to this video, as are all of the instructions and directions for writing to her. They are very strict instructions, but your letters and cards are getting her through. And she thanks you for them. Hi, Kel. Kel's been here for 26 months. She's also a moderator when she has time. Says, I'm a happy cupcake. Happy holidays to all. Thanks, Kel. We love you. Crazy Cat Lady says, Justin will get his karma. I always say karma knows your address. Karma knows your address. Thanks for being with me for 4 months. She's too cute by half became a member. And you are too cute. Fairy Raven, happy cupcake anniversary. 22 months for us. Thank you so much. Too cute by half says, I love your house, Melanie. We love having you here too. Thanks for being here for 5 months. Ms. Holmes says, I bet Justin's family are teaching the baby to speak. I don't know anything about their native language. I don't know. I have no idea. So Kelsey can't communicate with them. I don't know I have no information about that, so I can't even opine, but I thank you for your 5. Sarah says, the ugliest document ever. Emphasis added. Love you. I love you too, Sarah. Rhiannon says, his whole family must be sociopaths and no empathy, in her opinion. Thanks, Rhiannon, for being here for 10 months. Kat Randall says, Attorney Melanie Little and the chat are the best people. Thank you. And like a friend of dog, gifting 10 memberships. Thank you so much. And I see that there are 10 people that have just been gifted in the chat. So welcome to every single one of you. Welcome. Everyone smash the like button while you're here. We don't shut up about these things, even though they try. They try and make us shut up. Shut up. Oh, Stephanie, thank you so much. Just a little treat for the holidays. $200 is a very nice treat. Thank you, Stephanie. I appreciate you so much. By Venmo, she says, we adore you. Absolutely. I will let you know on the other thing. And I wish you and your family a happy and healthy holiday. as well. You're the greatest. Gigi, thank you so very much for your $50 cash app. She just says Merry Christmas. Thank you, Gigi. You're amazing. Always gifting, always so sweet, always so generous. That's why I say my chat, my choice, because the mean people we don't need the mean people here. The mean people can go be mean somewhere else. They have every right to do that. And I wish them all the best, but I don't need the negativity and the vitriol here because I'm just too old for that. I don't care about it and I don't need it and I don't need the drama and I don't need any of it. Hang tight for 1 sec. Roberta, thank you so very much for year 20. Says, interesting, after the verdict today and shootings, oh, you mean the sentencing? Maybe this was from yesterday. You mean Brian Walsh's sentencing. She says, and shootings at Brown and MIT, I think in Brian Walsh's mother's federal letter, she went to MIT for engineering. I love your coverage. Thank you, Roberta. Brian Walsh's mother, I think she did say she went to MIT, right? And for chemical engineering. Chemical engineering. I don't know. Remember when Brian Walsh went to the Lowe's with a list of what to buy, all the chemicals to buy? Hang on. I don't know. I just thought about that. And so it was just something that I thought about. That was interesting. As many people say that they think that she, meaning Brian Walsh's mother, was present on New Year's Eve. I don't know. Lots of cleaning chemicals, right? And remember the Googling of what kind of chemicals can dissolve a body or something like that? I don't know. There was no decision that came down from the SJC today. So there are 3 more business days left. Thank you, Betsy. I love you. Thank you, Betsy. You're awesome. Don't be silly. 3 more business days left for a decision before Christmas. But in any event, sadly, I definitely do not think Kelsey will be home for Christmas for her baby's first Christmas. And that should outrage you. Does it? Sherilyn, thank you so much. She says, Justin tells me all I need to know about him and his family. Thank you, Sherilyn, for your cash app. Friend of dog again. Oh, Mrs. Bouquet, is it your birthday today? Happy birthday. Happy birthday. Everyone say happy birthday to Mrs. Bouquet. Thank you. Thank you for your super chat and happy birthday to you. And hello to Harrison, if he's watching today. Hopefully you guys are doing something awesome for your birthday. Iceman Cummins says, hey, Mel, just want to let you know that the Clenny trial date is April 27th. No need to discuss right now. Just wanted to let you know. That has been pushed, right? It was supposed to happen in January. Thank you. Sarah Grace Patrick may start in January. That may be pushed. But I am interested in that. But again, it's hard to plan because, these things get adjourned and then we plan on something. That's why we like to just pivot. Oh, we did not do our badass affirmation of the day. Thank you for reminding me. Did we? I don't think we did. Hold on, I got to find the cards. Every day we have a deck called Affirmations for a Badass. We shuffle and we pull a card. Ellen said, I smashed that like button and it didn't hurt. She's been here for 7 months. Thanks, Ellen. Here we go. I know. Thank you, Iceman, for giving me that heads up because then I can take it out of the roster for now. Here's today's badass affirmation of the day. Okay, are you ready for it? I will not be an a-hole to myself. I will not be an a-hole to myself. That is your badass affirmation of the day. And that seems like an appropriate word, actually, for some of the people involved in this case of Kelsey Fitzsimmons. Thank you, Ellen, for smashing the like button and for being here for 7 months. And Carrie says, Merry Christmas. Merry Christmas to you, Carrie. And thank you, Carrie, for your super chat saying Merry Christmas. I appreciate you so much. Yeah, Kat Randall says, F everyone else but myself. Love you all. Well, you know, we have not read, and if you guys want to read it, we can. It is the reply brief to the SJC that was drafted by Kelsey's attorneys. Let me know if you want to read that. I think a lot of other people might have gone over it for you, but you know what? It's short, and let's read it. For those of you who are not familiar with what's happening with the appeal, this will give you, it's the reply brief, and it will give you a little bit of insight into the arguments on appeal from the defense. Oh, thank you. Thank you. I just need to, I'm getting parched. Hold. Okay, hang on a second. This is a very interesting comment. DempDog11 says, I'm a guy in the same court, you mean Essex, getting screwed 2 times as bad as Kelsey. I'm an Iraq vet, just being brutalized in that family court. That court refuses to uphold my custody plan. I'm so sorry that's happening to you. I'm so sorry that's happening to you. And we wish you all of the good vibes for things to turn around, because that's outrageous. And listen, it happens to dads and moms, right? Oh no, I'm sorry. Okay, so the hearing on Karen Reed's case has been adjourned. I'll show you the order on that. There is no hearing today. That has been adjourned until January 6th at 11 a.m. on Zoom. It's a very short order in which the judge kind of spanks both parties. That's in the O'Keefe versus Karen Reed Waterfall and CF McCarthy's. Also, something else that I found very interesting. Tell me if you're interested in this. Some news broke last night about Riley Keough, and I love Riley Keough. I just want to say that Riley Keough is the granddaughter of Elvis, for those of you who don't know. She was the star in one of my favorite TV series of all times called Daisy Jones and the Six. If you have not watched Daisy Jones and the Six and you're Gen X and you love everything 70s, go watch it. But there's an explosive lawsuit that was filed yesterday by some people that used to work with or for Priscilla Presley against I have to pull out the family tree because it's so complicated. There's a lawsuit that's been filed by some people that used to work for Priscilla Presley, for or with, against one of Priscilla Presley's children, Navarone Garibaldi. And in that lawsuit are explosive allegations that Riley Keough is the biological mother of John Travolta's son. Okay, that perhaps she donated an egg to John Travolta and Kelly Preston because they were not able to conceive, and that she's the biological mother of Travolta's son, Ben, and he's 15 now. It's like a soap opera. It's wild. I have the complaint. We can review it if you want on a different show because I want to do a separate stream for it. But tell me if you're interested in that. People are saying, I just want to point out that it's been a very, very long time since I've swiped myself out of this stream. Very long time. That was my left swipe. That is a very, very, very long time. I mean, I've been doing so well. I haven't done it in so long. So let me know if you're interested in that lawsuit because I would like to do a whole show on it. I would like to follow this. I love Riley Keough. And at the time, she would have been something like 21 years old. The allegations also are that Lisa Marie Presley donated some eggs to the Travoltas, but they didn't use them because they didn't want drugs in their eggs. This is wild. But it's in the papers, so I feel like I can talk about it. It's not just gossip. It's actually in the papers. Such an oddly specific allegation, right? Okay, you want to follow it? All right, we'll do it. Right, why was she donating eggs so young? Yes. John Travolta is publicly a Scientologist, right? He's with the Church of Scientology. Are also the Presleys is it Scientologist? Are they also followers of the Church of Scientology? I don't know. It's not illegal. It wouldn't be illegal. It would just be kind of explosive. Right? So if you're interested, we'll get into it more because I have, you know me, I don't like to do anything without papers. That's why it's so hard for me to report on this whole Nick Reiner situation, but we will. I mean, who didn't fawn over John Travolta back in the day? Saturday Night Fever was everything. It was everything. My hair, don't touch my hair. I worked all day on my hair. Don't touch my hair. Remember Father Frank? Why don't you call Father Frank? Father Frank won't call me. Why don't you just call him Ma? Father Frank won't call me. They actually made Saturday Night Fever into a musical. I think it was on off-Broadway. Lisa Marie was a Scientologist. Well, there you go. Lisa Marie went against David Cavage. She was going to testify against Danny Masterson. Oh, I don't know. Okay, yeah, I think that's something that we should get into. That's something we should get into. But in the meantime, let's read the reply brief that was filed by Kelsey's attorneys because we still do not have a decision yet. Here we go. This is the reply brief for appellant Kelsey Fitzsimmons. And this is how particular appellate filings need to be. It is very, very expensive to file an appeal because just printing alone is very expensive. It has to be in a certain font, in a certain format, it has to be bound, and in a certain color, and everything. And here's the table of contents. Table of authorities, meaning the cases that they cite. Introduction. Now comes appellant Kelsey Fitzsimmons and respectfully submits this reply brief in the instant matter. The Commonwealth's submission to the full bench dramatically expands its position far beyond the limited scope asserted in the trial court hearing under appeal and raises new issues that were neither presented nor litigated by them below. Appellant addresses those new contentions herein in the context of the appeal. Whether the Superior Court's revocation of release issued sua sponte. Okay, sua sponte means that's something that a judge just does on her own. Nobody asked her to do it. She just decided to do it. Nobody asked her to. In fact, the Commonwealth didn't even object to different alcohol monitoring conditions, but here's the context of the appeal. Whether the Superior Court's revocation of release issued sua sponte without notice, without proper findings, and without adherence to the law, constituted an error of law warranting relief under SJC Rule 221. Argument. The Commonwealth's brief improperly expands the scope of the appeal. Before the Superior Court, in the hearing at issue here, the Commonwealth stated only one simple request: to maintain alcohol monitoring. And that's right. Remember, they were oddly silent, the Commonwealth, during this hearing. They really didn't have anything to say. They didn't oppose it. All they said was, we don't care how you monitor her for alcohol. Just make sure that she's monitored and we're cool. We're cool. But they're not so cool on appeal. They just did an about face. Appellant, held under the court's order, agreed in principle, but by a different means, and the parties were not in opposition on this issue at that hearing. We were there. We weren't there. We had to listen to it. We had to order the transcript and listen to the audio only. The probation department likewise agreed that there was no violation. Despite this narrow framing, the Commonwealth now submits a 41-page brief addressing everything under the sun, disputed facts, praising and defending the Superior Court's actions, and presenting a narrative far beyond the scope of the question that was before the single justice. This expansion is inconsistent with the procedural posture of the appeal vis-a-vis the Commonwealth and obscures the core issue, the lawfulness of the Superior Court's sua sponte revocation of bail. 2. The Commonwealth relies on allegations the grand jury did not credit. The Commonwealth's principal factual argument relies on the assertion that appellant pointed a loaded firearm at a colleague, pulled the trigger, and attempted to fire again. These allegations were presented to the grand jury. If credited, they would have supported the requested charge of armed assault with intent to murder. That's a great point. That is a great point. The grand jury rejected that theory and returned only one count of assault with a dangerous weapon, an entry-level Superior Court offense. The notion that appellant intended to murder a colleague cannot be treated as a credible allegation, where the grand jury declined to indict on that basis. Yet, the Commonwealth's brief repeatedly presents these rejected allegations as though they were findings of guilt or fact. Dangerousness determinations must be tethered to reliable evidence, not accusations that failed at the grand jury stage. Well done, Mr. Bradl. Well done. Well done. Roman 3. The Commonwealth lacks standing to defend the Superior Court's sua sponte revocation. Because the Commonwealth neither requested revocation nor argued for detention in the hearing at issue, it does not have standing to defend the Superior Court's sua sponte decision. Another excellent point. The Commonwealth's stated position below was limited to seeking alcohol monitoring. Monitoring appellant agreed to, although only under the umbrella of the trial court's disputed release framework, provided it could be administered in a manner compatible with her documented injuries. The Superior Court, nevertheless, revoked bail without a motion from the Commonwealth, without notice to the appellant, and without findings under 58A or 58B. An argument not raised below is waived under Massachusetts Rule 30. Thus, a party cannot defend on appeal a ruling it did not pursue below, according to case law. Roman 4. The Commonwealth's assertion of trial readiness lacks support in the record. The Commonwealth asserts that it will be prepared for trial in January, a backdoor way of saying the wrongful incarceration of appellant won't be that bad. But at the time its brief was filed, it had not furnished automatic discovery, had not identified the firearm allegedly used, and had not provided materials necessary for independent expert review. Assertions of trial readiness are not relevant to the question at hand, and in any event are not supported by the current state of the record. Roman 5. Appellant's physical injuries were serious, documented, and directly related to her inability to perform SCRAM testing. The Commonwealth states that appellant offered no medical evidence demonstrating her physical condition. This is incorrect. The severity of appellant's injuries, a punctured lung, fractured ribs, and other gunshot-related trauma, was obvious, documented, and reflected in official papers. Probation staff witnessed her difficulty performing SCRAM breath testing due to her injuries. Nonetheless, the Superior Court failed to consider the impact of these injuries on appellant's ability to comply with the conditions imposed. The issue before the court. Until the trial court's surprise SCRAM ruling, was her mental state and lack of dangerousness, as supported by 2 esteemed mental health clinicians, not her physical disability. I have to read that again. The issue before the court, until the trial court's surprise SCRAM ruling, the issue was her mental state and lack of dangerousness, as supported by 2 esteemed mental health clinicians, not her physical disability. The Superior Court did not address the 2 expert opinions from Dr. Nisevic of Massachusetts General and Dr. Zeisel, concluding that appellant did not present a danger to herself or others. Roman 6. Contrary to the Commonwealth statements, appellant proposed a Contrary to the Commonwealth statements, appellant proposed a reasonable alternative to SCRAM testing. The Commonwealth asserts that appellant presented no alternative to SCRAM breath testing. The record directly contradicts this claim. Appellant proposed urine testing through a probation-approved vendor, an alternative Assistant Chief Probation Officer January identified as feasible. Yes, his name is January. The Commonwealth's repeated statement that no alternatives were offered is inaccurate. 7. The procedural complexity below resulted from the court's unexpected concerns. The Commonwealth characterizes the appellant's litigation posture as piecemeal. Here, repeated filings were necessary to address matters unexpectedly raised by the trial court's positions that alcohol testing was indicated. Urine testing was unknown to it, and the claim that what proof did it have? What proof did it have? 2 already filed affidavits that appellant's rib injury made it difficult to breathe deeply. Appellant's filings addressed issues as the court raised them, not by choice, but by necessity. Eight, the revocation cannot be upheld under either 58A or 58B. The Superior Court's revocation of release did not comply with either statutory scheme. A, if treated under 58B, required procedural protections which were absent. Revocation under 58B requires notice, a hearing, and findings of willful violation or new dangerousness. None of these occurred. B, if treated as reconsideration under 58A4, due process was still required. The appellee stated that the decision was not a revocation, but rather reconsideration. Regardless of label, 58A4 requires notice and an opportunity to be heard before modifying a release order. Appellant received neither. That's right, she turned that hearing into a totally different hearing. That's right, Peaches. Appellant's liberty may not be revoked under a statute that does not permit revocation based on the facts at hand, particularly without observing the procedural safeguards required by due process. 9. Footnote 8 and footnote 9 of the Commonwealth's brief contain significant misstatements. Footnote 8 presents a characterization inconsistent with the record and unsupported by any judicial findings. Footnote 9 misstates the role of the full bench under SJC Rule 221, suggesting that the full court is limited to reviewing the single justice's determination. In fact, where the single justice makes an error of law, the full bench performs de novo review and resolves the underlying bail question to prevent further unnecessary delay, and a remand to a lower court judge would have already made an adverse and then reversed ruling consistent with Stack v. Boyle. So what Bradl is saying here is that because the single justice made an error of law in her determination, of the original appeal of that order that the full panel, which has agreed to hear it now and which is reviewing it currently, can decide the underlying bail issue instead of sending it back to the lower court. And so perhaps the SJC may have the ability to release Kelsey under the same or different conditions. I mean, Mascot, if you're here, you can tell me if I'm reading that wrong, but whether they will do it or not is unknown. But de novo means with a fresh set of eyes, basically, a new review. The trial court's and the Commonwealth's discussion of mental health history omits the uncontroverted expert opinions. The Commonwealth references appellant's mental health background without acknowledging the two expert evaluations, concluding that appellant was not a danger. These opinions are unchallenged in the record and must be considered in any dangerousness analysis. 11, alcohol use played no role in the underlying incident. The allegations concerning alcohol derive from an affidavit submitted in a separate context by an individual with motives unrelated to this criminal matter, right? Justin. No police reports or charges are extant from this alleged behavior at a bachelorette party in Maine. No witness has been cross-examined or questioned under oath as to any of this alleged behavior. There is no rational basis to credit this piece of paper filed to gain advantage in a custodial family court matter. In contrast, law enforcement officers present on the day of the incident, present. In contrast, law enforcement officers present on the day of the incident did not report that alcohol was a factor in any way whatsoever and found a normal mother happily at home with her 4-month-old baby boy, her 4-month-old baby. The trial court's revocation cannot be justified based on untested allegations unrelated to the incident, particularly in the shadow of the mountain of evidence to the contrary. Roman 12. The Commonwealth did not address the ADA argument in its brief before the single justice and therefore waived it. That's what we said. I thought that could be their strongest argument. Appellant argued before the single justice that SCRAM breath testing was medically impossible due to her injury and that the Americans with Disabilities Act required a reasonable accommodation. The Commonwealth did not respond to this argument. Its first discussion of the ADA appears in the appellee's full bench brief and was ignored by the Commonwealth in the single justice session. Under Rule 16A9A, arguments raised for the first time on full bench review need not be considered. Conclusion. For the foregoing reasons, Ms. Fitzsimmons respectfully requests that the SJC, 1, address the bail determination de novo, meaning anew, consistent with the applicable cause, back to 1, address the bail determination de novo, consistent with the applicable case law, and 2, grant Ms. Fitzsimmons liberty with personal recognizance and a stay away order from the alleged victim under Section 57. No finding of dangerousness required. And the alleged victim in this proceeding is Noonan. Or Section 87, bail terms imposed with agreement of the defendant of the bail statute and vacate the balance of the trial court order, including the provision handicapping the probate and family court from handling the custody and visitation decisions in this case, and or grant other such non-incarcerated relief in the alternative if the court deems 58A conditions necessary, and send the case back to the Essex Superior Court before a different judge for the reasons set forth above. Wherefore, Ms. Fitzsimmons respectfully requests that the Supreme Judicial Court justices enter the appropriate orders as above. They want a different judge. Apparently, Judge McCarthy Neyman has reassigned herself this case for trial. And I don't know, based on the recording that we listened to, it seems like she might have some kind of bias against Kelsey Fitzsimmons for some unknown reason. And this was filed December 3rd, 2025. Let's go back to you for questions. It's just, this whole thing is just mind numbing. It's really mind numbing. I just want to check one thing. Hold, please. (16A9A). And that's the right citation to the SJC rule that says the argument of the brief shall contain the contentions of the appellant with respect to the issues presented and the reasons therefore with citations to the authorities and parts of the record on which the appellant relies. The appellate court need not pass upon questions or issues not argued in the brief. And so Tim Bradl and Martha Coakley are arguing because the Commonwealth did not even address the Americans with Disabilities Act argument in front of the single justice, they have waived that argument and they don't have any right to now decide to argue it in front of the full panel. And back to the chat. Hi, Nona 3. Thanks for your 5. Says Merry Christmas and Happy New Year. Love all you do every day. Thank you so much. I love having you here. Shuda says, just saw this headline from yesterday in Canton. Shoplifting suspect pulls gun on Canton police officer inside Walmart. Didn't see that one. Didn't see that one yet. Thanks for your super chat from across the pond. And Robin St. Rockin'. Thank you for your $10 super sticker. I appreciate you so much. I know. Unless you've heard the audio of that hearing, like you have no idea how heartbreaking it is. And it still haunts me. It still haunts me to this day. Maximum Bacon says, great brief. They do stellar work. I know. And listen, appellate brief writing is a very specific skill set. Many attorneys hire out and hire outside attorneys to do their appellate work because some attorneys, that's all they do all day. Tim Bradl actually drafted this. So good on him. Because it's very time consuming and you need an attorney with a special set of skills to do it for you. And so I would often farm it out and pay other attorneys to do it. Of course, I would review it. But oftentimes you're so busy with your other cases, you just don't have time to do the appellate briefs. And it's, or I had an in-house attorney that would do it specifically, but Tim Bradl did this. So good on him. Well done. So we'll see. Was it Proctor in Walmart? Says Miss T. Jules. Shari D says police officers are always protected up and down, left and right, and they're treating Kelsey like a fill in the blank. Yeah. Kelsey's also a police officer, right? But they're not on her side here. It seems. You have no power, Lori? I don't know where you are, but save the battery on your phone. That judge is awful to Kelsey, says that girl. And Deneen says, so will Kelsey have to remain in jail until trial? Well, if the SJC comes back with an order saying that she can be let out with conditions, she can be let out whenever that order comes down, apparently. So right now, the trial is not until February, We learned from the conference this morning that there's going to be another in-court compliance conference on January 13th. Mercury Stars says it's like their goal is to keep Kelsey away from the baby long enough to justify full custody. That's what it feels like. It feels like that. You guys, your internet is out too. High winds, right? Thank you on top for your super sticker. And so we are waiting. We're just waiting. We're just still waiting. So much insanity going on everywhere right now. Oh, Sherilyn, thank you. Thank you for another 5, says by Cash App. Merry Christmas to you and yours, and to you and yours as well. Thoughts, questions, comments, concerns. I mean, look, divorce happens. In this case, they never got married. I mean, the only saving grace of this is that Kelsey did not marry that guy and find out later. But you have to co-parent, okay, through divorce. In this case, they never got married. And it's disturbing. These papers are disturbing on a lot of levels. I know many of you in the chat have been through divorce and custody battles, not just in Massachusetts, but all over the world. And it's devastating. And one of the most important things that you can do in divorce is never badmouth the other parent to your child. Parental alienation is the thing. It happens. And he's telling us everything. Justin's telling us everything. He actually denigrated Mr. Page for financially supporting them, as if that was a bad thing for him to be doing. And then he threw in there Kelsey's mom's, in his opinion, excessive alcohol use. What? Love your kids more than you hate your ex, says Melissa. Great point. Thousands without power in Norfolk County? All right. Thank you, Hockey KC. Stone says, co-parenting with a narcissist is a nightmare. And Sarah says, I'd listen to Melanie read manuals for industrial machinery. Thank you. Thank you. And that's what Marcello says it too. He can see it all the way from Argentina, I think. So glad that they never got married. Otherwise, the house situation would have been lost for Kelsey. Mrs. Jim Marson is here, and she says it's sad when you wish your child was older to gain peace of mind. Oh, you changed your name to Mrs. Jim Marson. I love it. And I also love Jim Marson. Janine is outraged. What is wrong with the justice system in the Commonwealth of Massachusetts? Well, I don't know. Many of you have sent me emails about like the misogyny in Massachusetts. I even have a whole show planned on this and how it's starting to really, really show. Because look at like 5 of the cases that we've covered, right? Karen Reed, Sandra Birchmore, Kelsey Fitzsimmons, Penny McGee, and I'm just going to throw in Aiden Carney's case because Lindsay Gattani has been slut-shamed in public court filings by Cosgrove, and that is outrageous. That special prosecutor wrote all kinds of horrific things in his publicly filed court papers about Lindsay Gattani. And that is gross, in my opinion. And why? Why? Is the misogyny really showing? My opinion. Thank you, Sunny Mai Tai, for your matcha latte. She says, love you. Thanks for your coverage and hanging with us. Cupcakes. Merry Christmas. And Hope, thank you, I think, for your matcha latte from the other day. She's thanking me for getting her through her workday. Yes, I think that it was gross, unprofessional, and unnecessary. Let's talk about Lindsay Gattani's sex life in his responsive pleadings, in his publicly filed court papers. Something just happened to like the whole coloring on my screen. I turned pink. I don't know why. Maybe it's the internet. Anna Walsh was smeared too, in my opinion, says Lemmy Cephalopino Food Club. Yes, he did threaten Lindsay Gattani too, didn't he? That's right. I forgot about that part. Where he said, she better, I forgot exactly what he said. She's going to find herself in a situation where she could be prosecuted for perjury if she testifies in this case, because we don't really need her to testify. Outrageous. Yeah, I was like a shade of salmon for a minute there. I don't know what just happened. I don't know. Technology. Am I going to cover the Richard Allen appeal? I don't have it. I don't know. I have so much other things to cover, so many other things to cover that I can't promise you that. There are others who will cover it in ways that are amazing. Andrea Burkhart, I'm sure, will cover it, and she's amazing. Defense Diaries will probably cover it. They're amazing. But there are a couple of other things that I want to cover, including this new lawsuit that dropped about Riley Keough being the biological mother of John Travolta's son. And a lot of people feel this way, that the court is being used as a weapon with no due process for Kelsey, says Dreamy in Dreamland Allergic. And Julie says, and a lot of people say this, a lot of people say that I say exactly what you're thinking. I don't know, my one chat is behind but Julie said, I find I don't have to chat much because Melanie says what I'm thinking 98% of the time. I get that a lot. I am covering Lindsay Clancy. I've covered Lindsay Clancy a couple times already. Happy Rage Crocheting is here. We have a Rage Crochet Club for those of you who are not aware. We have a Rage Crochet Club. I need to update you on Aaron Spencer also, but I need to sit down and read those papers, which involves homework for me. Yes. And tonight I have to go into the city for a holiday party. So it is already 2:20. I need to get ready. I need to get my act together, and I need to go all the way into the city. And it is a horrible weather today. Horrible weather, rain, wind, all of it. It's one of the only days that I would say, thank God for the Long Island Railroad, because there are a few things that I hate more than the Long Island Railroad. And if you live here, you know. There isn't a Walmart in Canton, says Maureen. Oh, that's interesting. Oh, well, you don't have to, it's a club, but it's like Lovely Finds by Tiffany says, where do I find this crochet club? It's just everyone in the chat is rage crocheting when they get angry, and they send me pictures of like all of the amazing things that they crochet. And you guys are great. Great at crochet. I got to learn how to crochet. One of my girls knows how to crochet. She makes amazing things too, but I don't. On top is here says, oh, lots of fun. Be safe. Thank you. A rage club. It's rage clubs and rage clean. We have a lot of rage cleaners. And I also, Little Cupcake was baking. Rage cleaning is a thing for people, not me. I wish you could come rage clean my house. Rage knitting, you can rage knit if you want to. And Lola the Good Dog says, the judge saying that she can't come in person because he doesn't allow it for all prisoners. All prisoners are not treated equal, right? Well, they put her in Chicopee because they said it would be safer for her because she's a former corrections officer. And I guess she's on leave right now from North Andover PD. I'm rage procrastinating, me too. I think I should go buy some Christmas gifts and maybe decorate my tree. That would be good. Neither of which I've done yet. That was Canton, Ohio, says Liz Marie. Okay, thanks. So the Walmart is in Canton, Ohio. We now know that there's a Canton, Ohio. So she's all the way in Chicopee. It's 2 hours away for her safety. Allegedly. And On Top says, how about someone be safe? I thank you. Thank you. I want all of you to be safe too. Try to stay away from all of the vitriol and all of the hatred and all of the mean people out there, and just breathe. Just breathe. It's a great Pearl Jam song. Just breathe. All right, here's what you're going to want to do. You're going to want to set your notifications to all. You're going to want to make sure that you're subscribed. It's free. Just hit the subscribe button below because we do have lots of fun here. You're going to also want to make sure that you like the stream, that you comment when the stream is over respectfully, that you share the stream out so that other people can watch it and they know where to find us, and that you try and get your shopping done and stay sane during the holidays. And as today's badass affirmation said, also remember this: do not be an a-hole to yourself. Hold on. Okay? Because there's enough a-holes out there. Stay cool, stay kind, stay classy. I love you. I love each and every one of you. And Will is here. He's the glarer and he's rage meditating. That is good. Two things that are a little bit contradictory, but that's good. We all need to meditate and just breathe. So much craziness out there. Where do we even start? Thank you to the moderators for keeping it classy, because there was some, I don't know, some stuff going on. It's like an oxymoron, right? Rage meditating, it's an oxymoron. Like jumbo shrimp. All right, everyone. Stay cool, stay kind, stay classy. I love you so much. I love you. Oh my God. If I don't see you soon, I'm going to die. But you're not going to know when I'm going to see you unless you make sure you have all your notifications set. Okay? That's the deal. Thank the moderators. They're amazing. And I love each and every one of you. And I will see you very, very soon. All right. Peace, you guys. I love you too. I love you too, the Glara. I don't know why everyone just can't get along. Can we just support everyone? Can we just all be supportive of each and every one of us? Two things can be true. Just remember that. Peace. Love you guys.